Um, Welcome and thank you for coming. My name is Doug DeBancourt. I'm on the e-board for the Federal Society here at Suffolk. We're very excited today to bring back Professor Josh Blackman. He's come for the past third year, right? Third year? Yeah. And to have one of our own, Professor Pokrack as well. Just before we started, I think most of you have signed in. I need everyone to sign in that wants CLE credit, and I'll be dispersing the sheets at the end. But without further ado, I'll have these two professors introduce themselves and we'll get started.
Thank you. Thanks, Doug. Pleasure to be back here. I love coming to Suffolk. You guys have a very strong student body for an evening division, so I appreciate that. The Supreme Court is in a very precarious place. There are a lot of very high-profile issues already in the docket and some more issues that will come to the docket very soon. What I'd like to do today is talk about maybe some of the lesser-known cases that are actually pretty fun, and then lead into the bigger cases everyone cares about. So the first case is actually called O'Connor-Ratcliffe versus Garnier. Anyone heard of this case? It involves social media. Okay, so who here uses social media? Okay, you all do. I don't. I actually quit. I deleted my accounts. Best thing I ever did in my life. But a lot of people like to use it. So imagine that you have children and they're in school, and that there's a school board member who has a Facebook page, and you don't like what the school board member is doing. So you start putting comments on the school board member's wall, and you complain about this, and you complain about that, and you post the same comment dozens of times, verbatim, copy and pasted. And then after a while, you get blocked. So the school board member who's elected blocks you from their social media page. Is that unconstitutional? Now, this isn't just hypothetical. This happened with President Trump, you might recall. He would block people who would criticize him on Twitter. And this went up and down through the courts. It was Twitter at the time, but now we just drop X, right?
We don't even call it X.
Right? So Trump blocked his critics on Twitter and other platforms, and this went up and down the courts. And here's the question. Is Trump's tweeting state action? That is it acting as a state? And if it is, can Trump block people from seeing his tweets? Now, as you probably know, if you block someone, you can't engage with them. You can't see their postings. You have no idea what they're doing. I mean, of course, we all know you make a fake account, right? And then you log out and you log back in. You can see it in 5 seconds. So it's not really a block, but it's an impediment to accessing the information. So the lower courts actually held that Trump engaged in censorship, that he couldn't block people from accessing social media. But as we all know, and this did happen, he lost the election. And because he lost the election, the case became moot and it sort of just died out. But now the Supreme Court's taken the same case, again, involving school board members. So it's a sort of an odd First Amendment issue. Why? There's First Amendment rights on both sides. Let's think of it this way. On the one hand, you have the parents. The parents want to complain about their public elected officials. This is petitioning the government for redress of grievances. And they're doing it where? On the very page that they have, right? They're doing where most people see it by putting up their comments and complaining about stuff. But you also have the free speech rights of the government officials. Wait a minute, Josh, the government officials have free speech rights? You bet they do, right? In fact, they're maybe even stronger than you and me. If you're a government official, you need to be able to communicate to the public. And what happens if you have some parent who keeps spamming your wall, putting all this garbage in your wall, and it sort of distorts your message? Does an elected public official have the power to sort of curate what appears on their social media profile, right? So this case goes to the court, and the central question is this. Is managing a social media platform state action? And it's actually a very hard question. Why? If you're an elected official, is there any sort of statute or law that says you must maintain a platform for social media? Of course not, right? Most people just start a platform when they're running for office, and once they win, they just sort of convert it over. Second, is this actually a platform for disseminating government information? Or is it a platform for running for re-election? Because as you probably know, City Hall is not too far from here, right? Every politician, what they're always doing is trying to get reelected or reappointed at any point in time. So it's actually a very hard question. This case was argued back in October. It's actually argued on Halloween. And I suspect that the court will probably rule that there are some limits on when people can be blocked. But there's actually a lot of tricky elements here, and I'm not sure exactly the court will come down. But I think it's a fun case. All right. The second fun case we'll get to before we get to the really hard one involves trademark law. Okay.
This is funny.
It's actually a very funny case. So, do you remember? This may be if you're dating them. In 2016, Marco Rubio was running for president against Trump. And this is gonna be gross. I'm sorry if there's a Title IX violation. And a comment was made about Mr. Trump's anatomy. And he said, Mr. Trump has very small hands. Remember this? And of course, Rubio wasn't talking about the size of his hands. I'm just going to leave it there. That's all I'm going to say. All right. So this happened. So then you have a person named Mr. Elster. He's like, aha, I have an idea. I want to print T-shirts making fun of Trump. And the message in the T-shirt will be Trump too small with little hands going like this. Trump too small. You got it. You got the gist. You got Suffolk. You got it right. Maybe at Harvard they need a picture, but you guys get what I'm talking about here. No, I will not draw a picture. There's a picture. You can Google it. I'm not giving it to you. And so you registered this phrase, Trump too small, with the U.S. Patent and Trademark Office, and he sought a trademark for it. It was denied, right? It was denied. And the reason why it was denied is not obvious. It's not because it was offensive. In fact, the Supreme Court said a couple of years ago that you can't deny a trademark because it's offensive. Right? This was Mentality Tam, which involved an Asian American rock band called the Slants, which served as a pun or play on this. So they had slanty eyes. But instead, there's actually a statute. It's very old that says you can't register a mark that identifies with a living individual. So if you want to make a trademark saying that Josh Blackman's an awful professor, you need my permission to do it. Now, you can put that on a T-shirt all you want, right? No one's stopping you. You can put this on Facebook and Twitter and X and whatever else, but you can't seek a trademark of Josh Blackman's an awful professor unless I consent, which I'll give it to you, whatever. I don't care, right? These my evaluations are public. It's not a secret. Mr. Elster filed suit, and he argued that this is a violation of the First Amendment. And again, this is a case where there's sort of free speech issues on both sides, right? Because one, Elster wants to be able to promote and market his message, and he wants a trademark for it. But you may not know this. Can you put a message on a T-shirt without a trademark? Of course you can. What's the effect of having the trademark? It gives you a monopoly on that phrase. So if Mr. Elster receives a trademark on Trump too small, then all of you would not be able to put the trademark on the shirt. You could actually be sued for a trademark violation if you use his mark. So this is sort of a weird case where there's really kind of free speech on both sides. I think like actually the first case involving the social media, and the second case is whose speech rights are we sort of favoring? The rights of Mr. Elster, who made up the slogan, or the right of the people to publicly criticize Mr. Trump's anatomy, right? So again, this case was argued some time ago, and the arguments turned to what might be called viewpoint discrimination, right? The statute itself is viewpoint neutral. All it says, vote taken First Amendment or common law, right? All the law says is you can't identify a living person in your mark. It doesn't say you can't criticize him or you can't praise him. It's a neutral rule. And I think the court will probably come down and say that because this rule is neutral, it doesn't run afoul of the First Amendment. There's also the issue of government speech, right? When you're issuing a trademark, are you actually censoring speech? And the answer is no, right? The trademark doesn't stop anyone from speaking, right? If anything, the trademark says other people can't speak. So I suspect the court will rule against Mr. Elster. And if you want to put on a T-shirt that Trump is too small, you can do this without regard to any trademark lawsuits. All right. So now I'll turn to from the sort of the funny to the. All these cases involve Trump. I didn't realize that till just now. Right.
You could put like Stumpy.
Yeah, but the first
Stumpy
case
too
with
small.
social media was Trump. The second case, Trump too small. The third one is Trump in trouble, right? But yeah, they're all Trump. That actually wasn't deliberate. But the Supreme Court has a very, very healthy dosage of Donald Trump cases this semester for whatever reason. Okay. The first case I want to talk about, maybe we'll be more later, involves insurrection. All right. So we all know we were all here on January 6th. We all saw what happened. We all were living it in real time. I imagine, the same way that you might talk to your grandparents at Pearl Harbor, or that's how people talk about January 6th. Like, where were you when it happened? I was sitting at home under lockdown, right? That's where I was. But I was watching on TV at least. In the wake of January 6th, President Trump was impeached shortly thereafter, and he was tried, and he was not convicted in the Senate. What was he charged with? What was the article of impeachment? Inciting an insurrection, right? The argument was that his speech at the lips and perhaps some of his tweets beforehand incited an insurrection. He was acquitted. Now, why was he acquitted? Some senators said, well, because he's already of office, you can't convict a person of office, so we're going to acquit him. All right, there are debates back and forth, but he was acquitted. Okay. Over the next 2 years, no one was actually charged with engaging in insurrection, right? Not Trump, not the Proud Boys, not the Oath Keepers. DOJ did not indict anyone on the federal insurrection statute. But people were indicted for other things. For example, trespass in the Capitol, destruction of government property. One of the common charges is obstruction of official proceeding, that is to stop the counting of the votes. Some people are charged with seditious conspiracy, which is something I think less than insurrection, but exactly what it means is not clear. But no one was charged with insurrection. Why does this matter? Section 3 of the 14th Amendment discusses insurrection. Now, you all say the 14th Amendment. It's got due process. It's got equal protection. It's got the enforcement power. You've all studied this, right? But that's all the stuff you study in common law. Then there's the other stuff no one cares about, sections 2, 3, and 4. Right? Section 2 involves voting rights. Section 4 involves the debt of the United States. You couldn't care less. But Section 3 is important. Section 3 is a mouthful. I won't even read it to you. It's long. But what it says at a high level is that if certain people engage in insurrection, they are then disqualified from holding certain offices. And then Congress can remove that disability by a 2/3 vote in each house, which is a very high burden. That's what it takes to actually pass an amendment, to approve an amendment to Congress, 2/3 vote. So in the wake of January 6th, a lot of scholars and people start saying, well, wait a minute, isn't Trump disqualified from holding the presidency again? Doesn't this knock him out? And in a number of states, voters brought lawsuits. Now, you may ask, how can voters bring these lawsuits? State election law is very weird. And it's in many states the case that a voter can challenge the eligibility of a candidate. Sometimes you might need an opposing candidate to bring the suit, right? Every state's a little bit different. I don't know how Massachusetts law works, but some states allow this. There's also the issue of, I'm sure you watched the returns last night, he's not the nominee yet. At this point, we're still in the primary process. Can't people select who they want their nominee to be without regard to the Constitution? Again, there's some questions. At least the Minnesota Supreme Court said, Section 3 matters for the general election, don't bother for the primary. Of course, the upshot is that means the guy might be on the ballot and may not be able to hold office. That's problematic too. But really where all this came to a head is in the great state of Colorado. A trial court judge held a 5-day hearing. And the trial court judge ruled that Trump is not disqualified. I'll get to the specifics in a minute. And the case was appealed to to the Colorado Supreme Court, which reversed and said, yes, Trump is disqualified. At that point, it had to go to the U.S. Supreme Court, and the Supreme Court will hear arguments in about 14 days on the 8th of February.
On the 8th, right? Yeah.
Yeah, on the 8th. I'll be there. I'll be there with a smile on my face. Maybe not. I don't know. I told someone that I was going to D.C. for a January 6th hearing. Like, is it yours? Right? I was like, no, thank you. Okay, I'm good. But there are several, I think, very difficult questions in this case. Just for disclosure, I filed an amicus brief on behalf of Professor Seth Barrett-Tillman, arguing that Trump is not disqualified. I'll get to that in a minute. So the first question people ask is, Josh, was there an insurrection on January 6th, right? Was the riot at the Capitol insurrection? And I'll just say this is actually a very difficult question. The reason why is that there's not a single definition of insurrection. There have been many riots throughout history where some people said, that's insurrection. Other people said, no, it's not. I think it's significant that no one's actually been indicted for insurrection. We have an insurrection statute. Government's not charging them with it. So I think it's actually a hard question. People say, oh, of course it was insurrection. They haven't done enough work. Maybe 2 or 3 people have, but most people haven't. The harder question is whether Trump engaged in the insurrection. Section 3 isn't enough to just say you support an insurrection or you give it aid and comfort. You have to personally engage in it. And that's a direct offense, not like an inchoate offense. Remember your crim, right? It's a direct offense. And I think merely giving a speech is not enough to engage in insurrection. Tweeting is not enough. He didn't go to the Capitol. He didn't knock down a window. He didn't put on a Viking hat, right? He didn't do the things you'd have to actually engage in insurrection. There's also the First Amendment, right? Generally think that giving a speech is protected. And you say, well, didn't he incite a riot? Well, he gave a speech and then maybe people had to walk about a mile and then break into the Capitol. Under the so-called Brandenburg Doctrine, there's a cooling off period that if there's not an imminent connection between your speech and the riot, it might be protected. Again, I think these are hard questions. I think the court will have to wade through a lot of evidence to decide whether it was actually an incitement. So I think the better argument is this is actually protected. All right. But those are all sort of questions that you're familiar with. Another threshold question. Can Section 3 be enforced by the states? Or is there a requirement of a federal piece of legislation? You may say, wait a minute, Josh, the 14th Amendment is self-executing. You don't need a statute. Yeah, you kind of do. If you want to sue the government for affirmative relief, you need a statute. Section 1983 is there. It's always your friend. You can always use it. Section 1981 is always there. It's your friend. Go to any big case from Brown v. Board on down. They all cite Section 1983. Read their complaints. I've done it. So I think there's a good argument that you need a federal statute to impose this disqualification, and the state courts can't do it under their own law. But then there's a sort of the technical, textualist argument. There's some language in Section 3. It doesn't apply to everyone. It only applies to someone who took an oath as an officer of the United States. That's the key phrase. If you took an oath as an officer of the United States. You've seen this phrase before in the Appointments Clause. You've all read it for common law, which says the president shall appoint the officers of the United States. Whether you're a principal officer or you're an inferior officer or whatever the heck kind of officer you are, the president appoints the officers of the United States. The president doesn't appoint himself. There's also a commissions clause. The president shall commission the officers of the United States. The president does not commission himself. There's other provisions where it's pretty clear the president is not an officer of the United States. So our brief argues that Trump is not covered. And this is not a new position. My colleague Seth Tillman's been arguing this since 2009. 2009, you guys were in middle school then? Right, a long time ago. I know, right? We get older, they say the same age. That's how it works. And so Tillman's been making this argument for many years. Therefore, we argue that Trump is the only president who's never held office before. He was never an officer of the United States, never took any other oath, so he's not covered. Okay. There's a second textual argument. Section 3 says if you're disqualified, you can't be a senator, you can't be a representative, and you can't hold an office under the United States. That's the language, office under. So you have officer of the United States, office under the United States. Is the presidency an office under the United States? We've actually not taken a position here, but a lot of scholars have said that this phrase in the 14th Amendment refers to appointed positions only, not the president. Yes, it's a good argument. We haven't taken it here, but it's a good argument. The upshot is the court has many paths to sort of avoid knocking Trump off the ballot. They can say it requires a federal statute, that Trump was not an officer of the United States, that there was no insurrection, that there's a First Amendment right. In order for Trump to lose, the other side has to run the table. If you're right about everything. If every single argument goes against Trump, then he's off the ballot. I think that's unlikely. The big question then is what the court does and which path they take. There's more Trump stuff on the horizon. For example, there's a case about a gag order where a trial court ordered that Trump can't criticize court staff and they can't criticize the government so much with regard to the Jack Smith investigation. There's also the question of absolute immunity. Is a president absolutely immune from any sort of criminal prosecution based on his official acts? That will probably go to the Supreme Court also.
Do you think that's going to go to the Supreme Court? I think that they're dying for it not to come.
Well, they're going to appeal it because I think.
Yeah, but appeal it. They can just say, they did a good job.
The court will, I think, have to deal with it. There's also the pending case in Georgia, which may fall apart. This is the question whether the state can prosecute the president for interfering with electoral count. It's kind of funny. We talk about abstention doctrines. Maybe Fannie Willis needs to talk about an abstinence doctrine with her staff, and that would be a good way to avoid her precarious situation. There it is. You're welcome. I think I've talked enough. Those are all the cases on my docket. Happy to hear what cases my dear colleague has. We can ask some questions. Thank you all so much.
Yeah, I definitely have Trump versus Anderson because it's such an important case. I think it is very tricky. And I'm not sure that the Supreme Court can, there might be a lot of reasons that are supporting Trump's position, but they're not all as strong as they might be. And then we have the problem of, do we give states power? I think that that's actually probably the biggest one. And so I'll start there. On the question, I mean, we should talk about the office thing really quickly. I do disagree with that idea. And all the parties do too, right? All the parties have agreed that the office, your brief says so, that all the parties say that it is an office and it's an officer. It's an interesting argument, but it's a version of, I was actually explaining this before, that it's like, there's some arguments that are textual that might be a little too clever by half. There's a lot of arguments why it is an office. If the Supreme Court, this is my view on this, having practiced in front of them, although this is a different Supreme Court, I get that. And this is probably the only Supreme Court that would consider that argument. Is like, if they decided that the former president was not an officer, and that's the basis for saying, therefore, he can be on the ballot, that would be peculiar, because then that would mean Biden, I assume you would say, cannot have the same protection because he was a senator. So if you're a senator who took an oath of office and you did all the insurrection stuff, you cannot be on the ballot. But if you're just the president who wasn't a senator or a congressman or had any anything to do with trust or loyalty or duty, then you can be on the ballot. It's just the Supreme Court would not go that way on that issue, I think. But kind of leaving that aside, I think the biggest argument is the question that you brought up, which is, and this is harder than I think you suggested, which is Section 3 of the 14th Amendment a preclusion, right? It's an exclusion, clearly, right? You're excluded from if. And there are caveats. Not everybody's excluded, certainly, as you said. But either, and there's two reads on this, and I think it's an interesting question. Either it's an exclusion like you have to be 35, right? And that has no release valve. You have to be 35. There is no, Congress can say 32 is okay in this case, right? But this is a special one. It has a release valve, which is, but Congress, 2/3 majority, and it's not a bill, doesn't have to go to the president, right? It's Congress votes. That's very specific, I think, in the Constitution, that they can relieve the burden. And frankly, politically, I have to tell you, I think that that's the way to go. I don't know why Congress hasn't started down that path. I think a vast majority of Congress, both Republicans and Democrats, would vote for that because they don't want this quagmire either. But anyway, it's not going that route for whatever reason. So then the question is, does this mean Congress has to do something to make it an insurrection or to, I don't know. I mean, if you're saying people weren't prosecuted, that's not Congress, that's the executive, right? So that's not going to be, I mean, and then the question becomes, why aren't the fact findings of duly elected courts in different states sufficient to determine that someone was engaged in insurrection? The history is kind of complicated on this. I will admit there was kind of like an easy band of people who fought for the Confederacy. And when there was a congressional kind of a blanket pardon, it was really at a time when the people who were seeking office were like the 16-year-olds who fought for the Confederacy, who now had come of age and were seeking office. And they're like, okay, we've done this enough, I think is accurate. And there are some people who what's the guy's name? Van Wild.
Blandingham,
Yeah, that guy.
Clement, the member of Congress.
But they were talking about him being vice president. There was a question about that, and he was kind of precluded from doing that, and nobody fought that. It didn't get anywhere. But it was clear that the state from which he was coming was saying, you can't do this. So that was a powerful statement. But like I said, the history's on both sides of this. I'm not sure how Congress would have to make this decision. Would they have to say it was an insurrection? Or, and this is, I think, the alternative view, that states, through their normal legal processes, which the Supreme Court gives deference to, can make that determination. What's interesting is nobody's deciding, and you brought this up a little bit, whether he can serve. They're really deciding a ballot question, right? And so the division I find kind of interesting, but it's totally mired in state law, is whether or not he can be on, right now the question is, can he be on a primary ballot? And Michigan's kind of like that. Minnesota said he can be. Frankly, Galvin here, the Secretary of State, says, parties decide, they could put, I don't know, Zaphod Beetlebrox onto the.
They don't know who that is. They don't know who that is.
Yes, they do. Mr. Ryan, you know who that is, right? Some fabulous creature from outer space who was also president of the galaxy. They could put that person onto the ballot if they wanted to. Not a real person and not, qualified, because they're not, I don't think, from this country at all. But anyway, so that is kind of the view of some people, but the problem with that is in other states, primaries are entirely paid for and organized by states. Caucuses are quite different. And in fact, we're coming up in Nevada, which is having both. It's having a caucus that Trump's involved in, but Nikki Haley is not. And it's having a primary, which Nikki Haley is involved in, but Trump is not. So there's going to be a headline before South Carolina, Trump wins caucus in Nevada. And there's going to be a headline that says, Haley wins the primary in Nevada. I mean, it's just going to happen. So, there's a lot of, so there's state-specific issues about who decides. And in the Maine case, which probably just from, maybe some of you live in Maine, but.
Really?
Or from Maine.
Oh, it's far.
So in that state, the process is you start with the Secretary of State, like it is, frankly, in Massachusetts. And so she made a determination, now that goes to the court, which is the legal system of the state. And that will eventually end up in the Supreme Court of Maine. So I think it's tougher call for the Supreme Court to craft a version of how to do this. And, I think that there are a couple, 3 votes maybe for not crafting a careful version. But I think that it's really important that people understand that when people say, let the people decide, people should just vote, right? Well, that's a political question, which I actually have a lot of sympathy for. But it's not it's a political question about what's the best thing for democracy and stuff like that. It's not a legal question. So the court, we would assume, would hopefully be deciding the legal issues, which are, they're numerous and it's a very sticky wicket for sure. But on this one, I think they're going to have to do it. I agree with you there. On this one, it's before the court. The arguments are on the 8th. It'll be, you'll get a good, I think, sounding if you can stick to it, Ms. Chrissy.
Do you think that maybe they might punt on the merits of it, given when I read the Colorado case, the way the dissent took issue with the fact that it arrived at their doorstep through the election code in a way that of Colorado that basically had expedited due process. So the dissent was saying Trump or the Trump side can get proper due process. So I was thinking maybe the Supreme Court might just say procedurally it's defective.
Well,
That this was a constitutional
They
issue
could.
that should have gone through normal.
but what are they going to do with all the other states? I mean,
that's
that-
what
that doesn't
I'm
seem-
wondering is there a point to punt it when literally all these other states are deciding essentially the same question? Like they're going to have to deal with it.
I think all states want them to deal with it.
Yeah.
I don't think that there's, I mean,
And-
how many amicus briefs were written in this case?
Well, only the ones, there've been 30 something filed, but that was only 40 something filed, but that was only in support of Trump. The other sides
Yeah.
haven't filed yet. Let me just put another wrinkle on this of why I think a punt was a bad idea. Even if the court holds this is a decision for Congress, not the states, then we go to January 6th of 2025. There's a
Yeah.
joint session of Congress. And what if there's a Democratic majority in both houses? Possible. Trump can win, but the Democrat can win both houses. It's possible. Look at the maps. And the House of Congress decide that Trump has been disqualified, and they knock out any electoral votes for him, and Joe Biden becomes president. Or maybe the vice president becomes president of the 20th Amendment. It's not exactly clear what happens.
Or they pick somebody else?
Or they pick Joe Manchin if he's in top three. Seriously, if he wins the one electoral vote from Maine, he can become he can become president. Weirder things have happened. So I think there's a very strong look. I've been a critic of the Roberts Court, a big critic. I know they like to be minimalist, but if they kick the can down the road, it will come back to them later in a much more volatile situation. You can't escape this issue. It's here. It's live. It's going to happen. And if I could just respond briefly about, they may not take a hypertextual argument. I did a lot of work on the Obamacare litigation. And there was an argument many years ago that I thought was kind of hard to swallow, that something can be both a tax and not a tax at the same time. And yet Obamacare is still alive and well. So I don't know. The court can maybe take positions that aren't appealing to everyone. But the advantage of the position that I've advanced in my brief, which Trump has adopted entirely, the Trump lawyers have more or less taken our position in their entirety, is clean. You don't have to decide if there's insurrection. You don't have to decide if Trump engaged in the insurrection. You can avoid the First Amendment issue. You can avoid what the 14th Amendment means for self-execution. If Trump was not in office for the United States, this issue is done, clean, consistent with lots of cases. I can give you cases saying the president's not in office for the United States from top to bottom. It's an easy issue. Now, I know professors don't like my position. They think it's a little too technical, too clever by half. But I think it's clever enough to resolve this case and might give the court an easy out.
I'm willing to put money on that one. Anyway.
I'll be back next year, see what happens.
Exactly. The other thing they could do, of course, is just say, well, it's up to the states. And so you'd have this is another thing they cannot do, right? They'd have a pastiche of like a bunch of states saying he's disqualified and a bunch of states saying he's qualified. I really do think the best way out of this entire thing is the democratic way under the Constitution, which is go to Congress and vote on it, right? And either Congress comes up and says, I mean, I don't know. I guess they're afraid that they wouldn't have enough votes to remove the exclusion, but that leaves him in the same legal position as he's currently in.
Yeah.
But I actually do believe this, just counting votes. I think Biden would push for that. I mean, Biden would rather have the election than,
I saw one survey that said 80% of Democrats think Trump should not be on the ballot.
But that's Democrats, not people who are elected. And I
think that if there was actually 2/3 of the House and the Senate willing to give it an amnesty, I think it would have been done a long time ago. I think, frankly, a lot of Democrats see Trump as the most vulnerable candidate, and they want him to be in this sort of posture. But that's a politics judgment, not a legal judgment.
Just in the iffy posture. So
Chaos is good. Go ahead. I'm sorry, I didn't mean to interrupt.
Okay. My other case is Rahimi, which I might have talked to some of you about before in class, but U.S. versus Rahimi, which is it's been argued. So it is like owning guns, Act 3, the dangerous gun owner, or gunning in America, something like that. I don't know what it is. But anyway, so this guy, Rahimi, is not exactly your Boy Scout for sure. So he was actually arrested for assaulting his girlfriend and then shooting at a witness. And so there was a protective order against him, and his guns were taken away. And then there's a federal statute, as well as other federal things, which I can mention, but a federal statute that says you cannot possess a gun if you are under a protective order for domestic violence, basically. Okay. There are some exceptions in the rule, but he doesn't fit them. So then, Mr. Rahimi, and who these people are is really important, like who the court takes as cases. You should remember is like they get to choose any case they want. So then he's being investigated for a number of shootings in Texas. This is in Texas. And the police search his house and find a pistol and a rifle. So then he's charged, not in the Texas case particularly about this, but for the federal crime of possession while being under a protective order. And his argument was that, well, I can't be charged with that because of the Second Amendment. So it goes up. District Court says you can be. And then the Fifth Circuit, which is having a bad record these days.
My beloved Fifth Circuit.
You don't love them, do you?
They're my people.
I know, they were my people too, and I didn't like them then. But anyway, and Edith Jones is still alive. I swear to God.
She's the most powerful judge in the country.
Yeah, she is. And she's like, she may not be from this planet either. But anyway.
I like Judge Jones. I've got her smile once or twice.
I think that you held her upside down to see that. Anyway, so they came up with a pure Bruin type analysis, and all of you have dealt with Bruin at some point, I assume, in your law school career so far. But they said, well, throughout history, or at the framing of the Constitution or at the original ratification of the Constitution, there weren't any crimes against domestic violence. So there can't be any preclusion of gun ownership because of domestic violence issues, which is, hello. That seems odd, but that is sort of the construct that Bruin has put courts in, or has invited courts to join about this stuff. The Supreme Court took it quickly, which, usually you can, I still think that Supreme Court mostly takes cases to overturn them.
That's usually the role.
Yeah. So, and the arguments were, quite interesting, I think, that even people who signed on to Bruin, Thomas didn't say much, I don't think, but even Alito and certainly Justice Barrett, they were saying, well, what does that mean? Is if it's just a history thing when there was no history of protecting women couldn't vote. So is that really the history we're going to look at? We're going to be that micro-organized about that history? Or are we going to think about history in a bigger thing, about taking away guns from dangerous people or people who are charged with felonies? So there was not a lot of love for the position of Rahimi in the case. I'll just say that. What they decide, I think, will be more interesting because they've really boxed themselves in with this sort of hyper-originalism construct that, it started with Heller, big originalism argument, but then it was kind of like, it was knocked into stone in Bruin, in an odd way. So that's one of the ones that's going to be interesting to watch. I don't think that it's going to take them that long to decide that one. So I don't think it's going to be June when they decide that case.
It'll be June.
You think so?
The challenge with Rahimi, and look, I agree. So I think the Fifth Circuit actually faithfully applied Bruin. The problem is I don't think the Supreme Court meant what they said in Bruin.
Right.
And I think that Kavanaugh, Roberts, and Barrett might want to pull back. The question is, how do you pull back without undermining Bruin itself? They don't want to admit that they were wrong like a year ago, right? That's something that they can't stomach. So if you like comic books, to retcon, right? How do you retcon Bruin? And what do you do?
But Kavanaugh and Roberts have an out because they wrote a concurrence in Bruin, which kind of like talked about these problems a little bit. Like, so Barrett's a little different though, but I don't think she's going to go with the defendant in this.
Right. And the question is whether the liberals join along to give it more sort of buy-in and in the process water it down some more and let Thomas dissent. So, is this going to be 9-0? Is this going to be 6-3? Is this going to be 7-2, 8-1, 5-4? Right. This can actually go many different directions.
Yeah. But I feel more confident about this case than many after hearing the arguments, frankly. So last thing I want to talk about is is something you know about, but I think this might have its fingers in so many other cases that I'm not sure how far it's going to go, which is the so-called Chevron deference. Some of you are upper level. Who here has taken an administrative law course? Thank you. Okay. So Chevron deference is a rule that was made 30 years ago, basically.
1984, exactly 30 years ago.
Which basically said, okay, we have this administrative state, and you probably know it's not the deep state. This is different. The administrative state is Congress creates something like the EPA, and then creates a statute about what they're supposed to do. And then the EPA, as an administrative executive agency, then issues regulations and rules. This is true for the Commerce and the Export Administration Act. Every sort of big thing that's regulatory gets put into the executive, and then the executive, frankly, has both quasi-legislative powers to make rules and regulations after time periods and public comment and all of that. And at the same time, they also have quasi-judicial rules in ALJs, which are, administrative law judges. So Chevron deference went like this. This is a complicated world. I'm going to give the best rap on this because we live in a very complicated world. Congress cannot really figure out the minutia of this. And so we're going to rely on the experts in the, because they're like, make sure the air is not polluted. Well, what's pollution? Is CO2 pollution? Is it not? This was an issue in Massachusetts versus EPA. The question is we're going to let the experts kind of decide these things and make the rules and regulations. And we're going to defer generally to the agency. Now, that's been kind of cockamamie in a bunch of ways. And there's two arguments, which are, I think, interesting in all these. The case of Loper Bright, and then there's another one. What's the?
Relentless.
These are about these herring fishermen who were asked to pay for the inspectors that occasionally rode on their boats. Okay. And they're like, hey, that's not right. And that's not what Congress wanted, or it's extended beyond the power of the administrative agency to do that, to get fees from us. So the Chevron deference would say, well, the experts have looked at it and that's okay. Although the courts always have power to say, no, that's not okay, but it's a reasonableness standard. So in these cases, they're asking the court to basically, well, the people who are arguing are asking them to get rid of the Chevron deference. What that would mean is they did not handle that question very well. It was an interesting argument. It just happened last week. Because there's going to be if they get rid of it, then what's in its place? Other people, Prelogar, who argued for the government, said, well, you can come up with an alternative. So there's two arguments. One is every 4 years, if you change presidents every 4 years, there's the chance that the rules and regulations are going to change. And this is not good for business. I'm actually very sympathetic to that. And I think there are fixes to that within the Chevron concept. And the other one was it's anti-democratic, right? You're putting legislative functioning into the executive branch. The argument against that is that's what Congress wanted to do, right? They gave the deference over. And then the second one is actually, interestingly, because of other rulings of the Supreme Court, the executive branch has become much more democratic in the sense that in about 3 different rulings, probably if anybody follows this, you know the one from the Consumer Protection Bureau one, which is basically the president gets to appoint these people, talk about officers, right? And so there's a lot more than, compared to 10 years ago, there's way more democratic control of agencies than there was 10 years ago. So the democratic argument is a little less strong, I think. And it's funny because Gorsuch was saying, I don't care about the businesses because they'll take care of themselves.
Mhm.
I'm worried, Gorsuch said, about the little people, which of course,
Fisherman.
no, he doesn't. But he hasn't exhibited a lot of care for little people throughout his career. Come on, he's a libertarian.
He likes
No.
Indians. He likes Indians.
Well, I think that that's fair, but
He
he
likes-
doesn't like truck drivers.
He likes gay and lesbian people. In his Bostock opinion, he's been helping out some people. He does.
Anyway, he likes his mom.
He does like his mom. That sounds really wrong. His mom was the director of the EPA,
Got
and
fired.
his mom lost her job in part because of Chevron, kind of. And he apparently told his mother he shouldn't have quit. He told his mom she shouldn't have resigned.
But what did the president want?
President gets what he wants.
And who is the president?
Reagan.
Yeah, so he's got a mom.
It's a mom.
He should star in Psycho, the next version of Psycho. But
Oh boy.
that's a good one.
Did they get the
Come on.
reference? You get the reference? Psycho. Norman Bates was his
There's
mother,
a new
but
one.
he was his
There's a
mother.
version out. Well,
It was a new one. Oh, the new one was terrible.
Yeah, nice.
Like Gus Van Sant. It was
So-
dreadful.
But these cases might touch all these other cases. And the one I'm thinking about, and I don't know, is they have not scheduled this for argument yet that I know of,
Which one?
the Mifepristone case.
The
don't think
the
it-
brief was filed today by the government. I think
Okay, so they'll be,
it's probably going to be in March or so, maybe March or April. So
does
it's-
everybody know something about the Mifepristone case? Okay, Mifepristone is one of 2 drugs that are used routinely in medical or chemical abortions, like drug abortions. And so there were a series of FDA opinions. One in 2000 saying it's safe and effective, one in 2016, and then one in 2020, which ultimately led to the ability to mail Mifepristone around the country without having to go to a doctor. The original one was you had to go to a doctor, and so states had a lot of control over medical, this chemical abortion methodology by restrictions on how you had to go and how many times you had to go. The 2016 and 2020 ruling, particularly during COVID, really changed that and took, the FDA said you don't have to do that, and so there was a case against Mifepristone. Okay. And this is a problem with the Fifth Circuit, I think. And the Supreme Court, too, right now, is the standing problem. And that's actually the issue in this case, which is the people who brought the case against Mifepristone is an organization. It's called the Alliance for
Hippocratic Medicine.
And the problem is just straight up standing stuff. So they didn't have any member who was ever injured. They claimed, well, some member might be injured if someday they give someone this medication version of abortion, and then that person regrets it and is upset and sad, and then the doctor will have to deal with it at some point. But they don't have any injury, and they don't have a imminent injury, which is usually a standing requirement. But there's a bunch of judge shopping goes on in Texas.
No.
Yeah.
Shocked.
But it's one of the few states who can get away with it because they put district court judges in specific courts rather than having a rotating pool, which most states do have district court. There's many district court judges. So there's 2 districts where one of them you've got a 50% chance of getting the happy judge, the unhappy judge maybe. And then out in, is it El Paso? Where's Cosmero?
Amarillo.
Amarillo. You're going to get him. And he's been kind of leading a bunch of these charges because he has a history of he has opposition to things like abortion. He has political oppositions. So he went forward and just said, okay, mifepristone's banned. Fifth Circuit ended up agreeing. What's interesting about the case to me is that they didn't take it on the question of like, can the FDA make these decisions? In some ways they did. But what they took it on was, one, does this group have standing? Is there just like standing, which is good because they've messed up standing a little bit over the last 2 years. And then the second issue was, could the Fifth Circuit make a determination regarding the 2016 or 2020 FDA ruling without a full record? And that's an interesting one too, I think. So both of them are kind of like standing and what did the Fifth Circuit do cases, but frankly, depending on the order of how they think about these things, because they think about things usually in a term. So there's a bunch of cases that end up getting wrapped up together. And I think that, there's an argument that if you took away Chevron deference, maybe the district courts would have more power over the FDA's determinations about medication. But this is the bad stuff. This is actually in Loper-Bright and in Relentless. Not Relentless, is it?
Mm-hmm.
Good. I was thinking it was going to be the Resolute. But they were saying, wait a second, like district court judges can make these kind of highly technical decisions. And the question by Kagan, which was a good one, was like, okay, so you know that Congress is going to regulate something about the internet, about AI. Is Congress going to make detailed findings and decisions about artificial intelligence? No, they're not. They really need another thing. There's all sorts of solutions that people have proposed which are interesting. Like, why can't these administrative agencies be part of Congress? That was an original idea during the 30s. But I could see how, can't you see how the mifepristone case gets wrapped up in the sort of Loper-Bright question? Although I think that they're after the standing in that case. So those are my extra ones.
Very good. I'll just make one point. I just Googled the District Court of Massachusetts, and guess how many Trump appointees are on your federal bench here in Massachusetts? The number is 0. So I count 13 total judges, this is active service, one W judge, the chief judge, and one H.W. Bush. So the fact is, in most big cities, you have virtually a 93% chance of drawing a Democratic appointed judge. So I'm not too much troubled by the forum shopping tax. It happens everywhere. In terms of Rahimi,
yeah, but you don't know those judges. They're not liberal icons.
maybe.
Kaczmarek is a right-wing icon.
Oh, he's a friend. I like him. So I call him a friend. But I think I think the Fifth Circuit does get a bit of a bum rap, but they do get reversed at a very high clip, which doesn't mean the Supreme Court's right. It means that President Trump made the wrong selections. Oh, just think,
Supreme
just
Court or in the Fifth?
Oh, for the Supreme Court.
Oh.
Just think, if President Trump had not picked Barrett, the barbed wire fence would still be up in Texas right now, right? If he had not picked Kavanaugh, Rahimi would not be in doubt. So look, President Trump made some selections. So as I say, you should be grateful that Trump made the ones he picked. Could have been worse for you. All right. We are almost at 7. I know we're respectful of everyone's time. Any other questions you want to ask us? We didn't really have time for Q&A.
I actually had a question about a case that you haven't discussed yet. It's the Moore decision with regards to whether
the income tax one.
Yeah, whether there's a realization requirement for federal income tax.
I've done everything in my power to ignore that case. I tried very hard to just not pay attention to it.
So there's this guy who's got some property. He's engaged in a little thing that's going on in what country is that in? Yeah, India. And he's got a corporation, but he kind of gets out of the corporation, but his friends running the corporation, and the property value of this thing is increased. So but they haven't sold it technically because it was transferred without a sale. Although it's a very complicated case because there's a question of like, is he an officer? Well, he took money and like, so there's different rules in taxation, but the basic line is a really interesting one. Can you tax unrealized value, right? So let's say you own Bitcoin, which of course is like a fantasy, right? It's not based on anything. There's no underlying value. It's valuable because it's valuable. Let's say you go from having $10,000 worth of Bitcoin to $3 million of Bitcoin, but you don't do anything with it. You just keep it locked in your blockchain. Can they tax that unrealized value? Which would mean, frankly, that you could take a loss on unrealized loss too. So if it went down, if you had $100,000 of Bitcoin and it went down to $70,000 worth of Bitcoin, you could take a loss that year. So that's the big question. I listened to that argument and it's so in the weeds because of the whole question about whether he was an officer or not an officer. I think they didn't take the best case for this. And also part of this is about unrealized value is a specific law applying to foreign assets, because we don't want people basically putting money in foreign endeavors, taking money out of the United States, if you want to think of it that way, putting it into foreign endeavors and then never returning the value that has been gained in that foreign adventure, right? So there's a lot of issues. What do you think?
I don't know, I just know that if it is decided one way or the other, I mean, a drastic decision on either side could have huge impact on the way that our federal tax system works. So for example, if they say that the hard stop, there is a realization requirement, then there's a lot of, especially as it pertains to businesses and corporations, there's a lot of in the tax code that could potentially need to be rewritten. Like Senator Paul, who actually helped write this tax that's being, that's the subject of this litigation, and said himself, if they institute a hard stop realization requirement, we're going to have to rewrite 60% of the tax code.
Oh no, do work in Congress. Well, I think that they could do status quo. That's actually what I'm expecting, which is there's kind of a specific reason that there's a realization requirement in situations like this, right? So, true value can be taxed from foreign assets only. That would not create the entire tax code rewrite, I don't think. They don't want to mess with the tax code that bad. They have other targets.
All right.
Actually, you were saying about all these things that are coming to the court. One of my questions is like, this court they're too thirsty. They don't have the patience of like the Rehnquist court of like waiting for the right case with all the mootness questions and, even Loper Bright and Relentless have a quasi mootness question. They're not going to decide it on that though. But they just want to get stuff done. They're eager.
All right. Speaking of getting stuff done, I think we are done with our time. I'm happy to answer any questions you have. Thank you all so much.
Thank you.
Thank you, sir.
Yeah, it was great to see you.
Thank you.